All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here.
Yeah.
All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Question. Is that an Article 3 trial?
To what?
Would that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you are wasting valuable time that all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately...
Clip 1. In State versus Matthew Aldridge, a man claiming to be attorney-in-fact appeared without legal authority and refused to confirm his identity. The judge made it clear, only licensed attorneys can represent defendants. His sovereign citizen filings were dismissed as invalid. The court then reset the trial for July 15th and warned Aldridge to appear or risk bond revocation in jail.
It will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrants? I'm going to put a notice up there for tonight. If we don't need you tomorrow, but we need you on February the 6th. February 7th would be a day I could give it. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry?
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get his card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
Arrest and arraignment. On May 19th, 2025, prosecutors filed a criminal complaint against 33-year-old Alexis Brown in the 14A District Court in Washington County, Michigan, charging her with assault or assault and battery. Ms. Brown was ordered to appear for an arraignment and pretrial hearing set for June 18, 2025. But she didn't show up. The court then scheduled what's called a show cause hearing for July 2, 2025. Once again, Ms. Brown didn't appear. At that point, the judge issued a warrant for her arrest. She was later taken into custody and, on July 14, 2025, appeared before the court for her arraignment. Since she hadn't posted bond, Ms. Brown stayed in custody after probable cause was found. 3 days later, on July 17, 2025, the Washington County Office of Public Defender formally entered an appearance to represent her. Assistant Public Defender Lauren Pern was ready to help, but Ms. Brown turned down that offer, choosing to represent herself instead.
Court calls the case of the People versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Pern on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So, in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washington County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you served.
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So.
Okay.
What do you want this set for, ma'am?
Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you got to make a decision, ma'am.
If it got to go to trial, then it got to go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
2. Miranda rights and judicial limits. Ms. Brown asked if her arrest was illegal because officers hadn't read her rights. Judge Simpson told her he couldn't answer that question. Contrary to popular belief, an arrest isn't automatically invalid just because officers don't recite Miranda rights on the spot. In the landmark 1966 case Miranda versus Arizona, the Supreme Court created a more specific rule. Before a custodial interrogation, meaning questioning while the suspect is in custody, officers must advise the person of their right to remain silent and their right to an attorney. If they don't, the arrest itself still stands, but anything the suspect says during that un-Mirandized questioning can be thrown out and not used as evidence later on. Even though Ms. Brown misunderstood the law, Judge Simpson couldn't explain it to her. Canon 3 of the Michigan Code of Judicial Conduct requires judges to stay impartial and avoid even the appearance of bias. Judges can help self-represented defendants understand procedure, but they can't give legal advice. If Judge Simpson had answered her Miranda question, it would have crossed that line and given her an unfair advantage. That kind of legal guidance is something only a lawyer can provide, not a judge.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she ain't got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole McDonald's thing and then this. And okay, let's try this one.
Jury trial rights. Judge Simpson then asked Ms. Brown to choose between a jury trial or a bench trial. A final settlement conference and jury trial were scheduled. Back in 1968, in Duncan versus Louisiana, the Supreme Court ruled that the Sixth Amendment guarantees the right to a jury trial in serious criminal cases. Then in 1970, Baldwin v. New York clarified that serious means cases where the potential sentence is more than 6 months in jail. Since Ms. Brown's charge was a 93-day misdemeanor, the federal constitution wouldn't require a jury trial. But Michigan law goes further. Article 1, Section 20 of the Michigan Constitution gives defendants the right to a jury trial even in misdemeanors with less than 6 months of jail time. Still, under state law, only Ms. Brown could waive that right. It wasn't up to the judge. That's why Judge Simpson had to ask her directly, and ultimately, she chose to go with...
Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
You
No, don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom, and you will not talk over people. You will present the evidence. I am absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I don't make, and I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we speak?
Do you understand that? Yes, you may.
Well, we tried to tell her, the funds, we can pay them. We have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor. I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially. But I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Upcoming proceedings and civil case. As of the date this episode was written, Ms. Brown's criminal case is still open. Her settlement conference is set for October 17th, 2025, and jury selection is scheduled to begin October 20th. The second case in this episode took place in the courtroom of Judge Kristen D. Simmons in the 54A District Court in Lansing, Michigan. On February 20th, 2025, Judge Simmons issued a judgment evicting tenants Chase Carson and Amanda Wilson and ordering them to pay their former landlord $9,808. The tenants didn't pay, so the landlord's attorney, Jessica Larson, tried to garnish their wages and bank accounts. Those efforts mostly failed because the landlord didn't have updated financial information. So on August 19th, 2025, the court scheduled a debtor's exam, a hearing where creditors can question debtors under oath about their finances. The hearing was set to be held virtually.
Well, then I guess I misunderstood. That goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language. You have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, the documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her in full.
You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the
Motion.
lady that might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number's on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
September 4th at 1:30.
September 4th at 1:30, you said?
Yes.
In person at the court. If you pays in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor, thank you very much.
Save the
You're all
tax
set.
and money.
Sergeant, mute him and remove him from my courtroom before he's in contempt. Mute him and remove him from my courtroom before he's in contempt.
Judgment resolved and lesson on self-representation. Judge Simmons rescheduled that debtor's exam for September 4th, 2025, ordering Carson and Wilson to appear in person with the financial records attorney Larson had requested. On the day of that hearing, Larson filed a certificate showing the judgment had been satisfied. These two cases show the real risks of going to court without a lawyer. Ms. Brown clearly didn't understand what her hearings were for or how Miranda actually works. Judges can explain procedure, but they can't give legal advice without compromising their neutrality. A defense attorney could have explained her rights, figured out whether there was custodial interrogation, and, if needed, filed a motion to suppress her statements. Likewise, in the civil case, Carson and Wilson didn't fully understand courtroom procedure or how to challenge the judgment against them. A lawyer could have helped them follow proper steps, file appeals on time, and avoid unnecessary trouble. The bigger takeaway: the legal system is full of technical rules. Without proper legal guidance, people risk misunderstanding their rights, missing deadlines, and asking judges questions they can't legally answer. If there's a case or courtroom interaction you'd like us to cover next, drop it in the comments. Thanks for watching, and don't forget to like, share, and subscribe to help build a more informed society.